Okay, well, here we are again. It's Robert Bond at Bristow's law firm. As you know, we regularly do webinars on compliance and particularly data protection or data privacy topics, but we're also very actively involved with the Data Protection Network. And apart from the speakers that we've got today on this topic, I'm joined by Rosemary Smith from Opt4, who was responsible for starting the Data Protection Network. So, Rosemary, do you just want to tell people a little bit about the network and what we're doing and why we're all here?
Absolutely, yes. Well, the network, we put the network together a couple of years ago now, and the idea was to create a resource for individuals who are facing challenges from privacy compliance on a daily basis, to do it in a way that is in plain English and is easily understandable. The website, which is dpnetwork.org, has a significant amount of free content. The idea being that we're trying to help people raise their game, help people understand the importance of data protection compliance, but also how they can maximize their marketing permissions, how they can actively provide really positive statements to individuals to encourage them to share their data and allow their data to be processed. So we've got a lot of content there. We run these webinars on a regular basis on specific topics, and we are also, through our governance board, of which Robert is chair, we're looking at a range of issues, one of which is the GDPR, the upcoming new regulation that's coming in May of next year. And most particularly an area of focus for us is guidance on the use of legitimate interests to pursue processing as an alternative potentially to consent.
Okay, thank you, Rosemary. And in a minute you'll see that we've had in some questions from attendees, and indeed one of those is around legitimate interests, so we'll get a chance to maybe explore that in a little bit more detail. So today I am joined by Michelle. Michelle has a healthy interest, as she says, in practical data know-how, and has had a long and interesting career within the industry, and before joining Age UK was in the retail sector, both Argos and Arcadia Group. Michelle is a board member of the Direct Marketing Association, a fellow of the Institute of Direct Marketing, and a board member of the TPS. And so she is well equipped to talk about DP as it relates to charities. And we are also joined by George Kidd. I'm delighted George is here to bring a more regulatory, I was going to say quasi-regulatory, but I think I ought to say regulatory approach. George is Chief Executive of the Senate Group, the responsible body for gambling services, but he's been non-exec Chief Commissioner at the Direct Marketing Commission for 6 years and is responsible for, as many of you know, in the fundraising world, some really interesting insight into the way in which we should not just legally but perhaps more ethically approach the business of fundraising for charities and not-for-profits. And I'm sure as we go through the next hour or slightly less now, we will hear much about regulation and law, but I think we're going to hear an awful lot about trust and reputation and ethics, because that is where we are heading, not just now, but GDPR is pushing us in that direction, as are most other laws around the world in this area. And then finally we have Simon Blanchard, who is a senior associate with Rosemary's company Opt4. Simon joined in February 2015 and is working regularly with large multinationals, but also for companies within the charity sector. And so we thought that this would be an ideal other person to have on the discussion. And apart from our three keynote panelists, I'm sure that Rosemary and I may chip in from time to time.
Try and stop me, Rob.
I was just about to say try and stop me too, Rosemary. So from an admin point of view, just to remind you that this is being recorded, so you will be able to download the recording after the webinar in 2 or 3 days' time. Also, we will make available a PDF of the limited slides such as they are on this occasion. And you can, of course, as we are going through the questions that have been sent in advance, use the question box to send in any further questions or comments you've got. And Jana, who is sitting beside me, keeping an eye on the incoming mail, will pass across to me anything that she feels is appropriate, which we'll deal with either right then or we can park it until towards the end. And the end will be at 5 p.m. sharp. So without further ado, let's look at the questions. We did have lots and lots of really good questions with some similarities. So some of you may recognize precisely your wording from the questions you sent in, and some will look at it and say, yes, that probably is more or less what I asked. So I've concertinaed or scaled down to these questions here. They're not in order of importance, ascending or descending. They're really as I drew them off the Excel spreadsheet that created these questions and the sign up. So let's just see over the next 45 minutes how we work our way through these, and any others that you feel you want to email in. So how do we define our approach to direct marketing? And let's start with the lady on my left, Michelle. Because you said, oh, go on, ask me first, didn't you?
Did I?
We know you.
Oh. Well, how do I define our approach to direct marketing at Age UK? Well, first of all, it might be worth me saying that how do I define direct marketing? Well, I use direct marketing to prospect in terms of sending fundraising appeals. I ask people if they'd like to participate in events. I also ask them to campaign, possibly volunteer for us. All those communications, to my mind, are direct marketing qualifications. So in defining what it is we do that is direct marketing, I would then say that we then look at the current Data Protection Act and we start to work out how we are going to acquire personal data using direct marketing and what permissions we are going to capture as part of that process. So as an organisation, we, for example, will send a fundraising appeal. We are looking to raise income for our cause, and we don't lose sight of that. In doing so, we will communicate with individuals who we already know. We will look to acquire new individuals, and we will ensure that they are appropriately permissioned. So we will, in terms of transparency, go through the process of explaining what we're asking permission for, really, and I think that's noted as possibly changing from purpose to activity going forward. So many of you may be familiar with the statement, we'd like to tell you about all the things we do to help older, younger people, animals, health and so forth. That will probably need to be a bit more prescriptive going forward, so that's something we're preparing for. We're also going to be sure that we tell the person responding exactly who we are, where we are, how they can contact us. We have found from research that, and whilst as an organisation we have never sold data, that individuals quite like to hear that from us. They like to hear that we will take very good care of their data and we have no intention of selling it on. And then we go about collecting our permissions at a channel level. So our approach to direct marketing is to run a campaign that we would hope would bring in enough money to make it profitable for us, but in doing so we hope we are respectful of those individuals who have chosen to respond and give us money.
And just before I ask others to chime in, one of the things I was thinking as you were talking there, and and this is somewhat specific to Age UK, but it strikes me that there is never really a one-size-fits-all approach to this, because even the language that you may have to use would be entirely different for the usual donors and supporters of Age UK, in the same way as if you were dealing with Childline, you would be having to rethink the language that's used to get that transparency and communication across. And I mean, is that something, George, that you would agree with, or how have you, in your capacity, approached this question?
I think it is something I would agree with. I'm now very old. Well, I'm in my 50s. I think that's very old. I've hardly worked in a for-profit job in my life, and therefore I'm loath to tell people how to go about direct marketing when I've never done it properly myself for a living. So that's my disclaimer. I think there's a challenge here, which is the distinction between the law, the regulations, and we're going to come to them, and as you said earlier, ethics. And what struck me when we started this was thinking, well, the Direct Marketing Association, and I operate their code of practice, moved from 177 pages of code to 5. And the 5 were principles. And when I looked at this question about definitions, I thought, well, the ASA talk about legal, decent, honest. We wouldn't quite crib those, but I was writing down wide it's not a principle, but direct marketing, as Michelle has said, is widely defined, and to pretend it's not is disingenuous. But then I think they are principles. So it's being straight, it's being respectful, it's being relevant, which I think we're all learning a lot about. I hope it's about being valued. And the last one, which is a strange one for me, I think, as a quasi-regulator, as you describe me, is being unapologetic. This is a legitimate activity. It's a valuable and necessary activity, and done well, we benefit from it. So I think there is a risk when there's all this conversation about legitimate interests and consent that we get to the point of we're seeking your permission to do something unwelcome, and actually that shouldn't be the nature of the relationship.
Okay, good. And Simon?
Yeah, completely agree with both points that Michelle and George have said there, really. So just in terms of kind of adding, I guess, a slightly different perspective, I guess, on that, I think just building on that whole point really around trust. That's what it's all about at the end of the day, is being able to demonstrate that the organisation, that the charity are trustworthy, and being very transparent, obviously, about how you're going to do that. And I think that plays into the granular kind of consent and the options as well, and the amount of control that you can give to an individual by giving them choices. So to be able to talk about the different purposes for which you offer communications, and you'll do your marketing, to be able to break that down in maybe a bit more detail than charities might have done in the past. And as Michelle said, about offering them choices around the channels that they might wish to communicate. And one thing I just kind of add to that really is around thinking a bit more about maybe the value proposition that goes along with that when you're capturing a consent. So I'll give you an example. So SMS, for example, is one that, again, quite often where an organisation will ask for a consent for SMS, and generally those kind of opt-in rates are very low. And that might be for a reason, is because there's often not an attempt to explain the role of the SMS and what benefit can be provided through a channel like SMS, and with others as well. So sometimes some channels will suffer from certain perception, the likes of SMS, but also direct mail for that matter as well, the customer's perception. So I think if you want to do the best in terms of being able to reassure your customers, or supporters actually I should say, if you want to be able to reassure them and to encourage them to kind of give a consent and to start to build that relationship in a good way, think about how you can communicate what those kind of communications are going to look like and what benefits they'll do, and try to reassure customers that they can be personalised and that they'll have control over what you send them.
So if we just continue that theme, and if you look at the slide we've got there, I am actually going to jump to bullet point 4 because it dovetails with a question that has just come in, and I'll read the question and then we can talk around these. What do you suggest will be a satisfactory proof of consent as evidence that somebody has agreed to what we are going to be doing with their data, i.e., signing up through a newsletter or online, etc., or at an exhibition? So going back to what Simon was saying and where Michelle started, we have this question at number 4. What tips do you have for consent notice? So if we look at the ICO's current consent consultation, and it's the 30th of March today, and that consultation closes tomorrow. And I would put a plea in to anybody that is on this webinar, if you haven't yet got your head around that consultation, I would seriously look at it, please, because I think some of what is being said by the ICO is extremely sensible, and then there are other things which are worrisome, of which one is we're supposed to now say who all of the specific third parties are that we may share data with. So in this tips for good consent notices, we've got to think about how do we get unambiguous, freely given consent based on plain language, specific notices, with the right at any time for an individual to say yes one minute and no the next minute, and to be able to slice it up between direct mail and SMS and so on. This is a nightmare, isn't it, for any business, not least a charity. Michelle?
In terms of tips for consent notices, we at AGK have gone through quite a lengthy process in the last year, as I imagine many of you have. So, number one, we looked at our privacy notice, and we have made the opening statement, i.e. what are we going to do, how are we going to use your data. We tried to focus more on activities. We haven't listed them one by one, but we've broken them down into broad areas, and that's replaced the sort of de facto, we'd like to tell you about all the things we do for older people. So you should be in no doubt, when you look at that notice, what it is you're signing up for. We've expanded our privacy policy and put the link to the privacy policy where we printed the privacy notice, where we're talking about direct mail. That's actually in with the privacy notice. It isn't stuck on the back of a letter or on the website. It's not right at the bottom. It's actually within the area of the privacy notice. And we tried, I must say, I'm quite pleased with our efforts on our privacy policy, because we have inadvertently taken Rosemary's advice to use plain English, and we have tried to explain how we might use profiling, how we work with data processors, so where we employ third parties to process data for us and so forth. We've worked quite hard with systems behind the scene, which is terribly, terribly boring. I quite like it personally, but most people shudder. Everybody loves the notice, and then obviously what you're collecting has to go somewhere. And finally, probably the thing that will save you if you do come under scrutiny is the old-fashioned guard file. You can make it electronic if you want. So what did Rosemary see in February? You will know which privacy notice she saw, because you will be able to track which campaign she responded to, allegedly. And if you have a hard or electronic copy of that, that is your proof to demonstrate that Rosemary did in fact see the message and she was offered channel opt-in and a privacy policy. If she is an existing donor, again, by campaign, by date, you will be able to show a scan of what Rosemary saw, and if she's an existing donor, you should have actually given her at every touch point an opportunity to opt out. So signpost her via telephone or valued supporter at yourcharity.org.uk. So in that sense, there is a full end-to-end journey for the donor in terms of either opting in or opting out, and for you to prove that you have in fact collected that piece of information.
I think it's great, isn't it? Because it's what you're talking about there is a combination of the two huge requirements in GDPR, which are transparency and accountability. So the two things, and you're talking about how you're moving in the direction of being GDPR compliant now, which I think a lot of organisations have started to think about. That level of that transparency, I think, hooks into the trust, and it hooks into, and the accountability also hooks into trust. So if I ask Age UK, come on, when did I give you that consent? You'll be able to tell me. You'll be able to tell me absolutely with no question as to when that consent was obtained, and obviously offer me the opportunity to withdraw that consent if I want to. But I think one of the points that I would make, and it's kind of the elephant in the room we haven't talked about here, but the charity sector is under significant regulatory scrutiny at the moment. You can argue whether that was created solely by the Daily Mail on a quiet day, or whether it was actually created by some fairly bad practice that potentially had been undertaken in the name of charities, whether knowingly or not. So I think there's a big issue for all charities to try and regain ground, and by using transparency and proving they're accountable for data use.
Yeah, and unfortunately, once your head's above the parapet, your head's above the parapet, and it's very difficult to get off the radar, to use another expression. I mean, Simon, you're again at the sharp end, trying to work with a range of different clients. How do you road test the consent notice? Do you do that with, I mean, obviously you have done that, Rosemary, with Age UK, but is that a standard approach that you take to sort of kick the tyres on the consent notice?
I think that's absolutely right. Yeah, to look at much as Michelle said, to review the existing consents from the point of view of, are they clear enough? Are they transparent? What would I understand by that? And particularly, quite often they're not detailed enough. And I'm not just talking about charities here in general, talking about just getting updates or something like that. Well, what might that mean? So being a little bit more detailed about what is included within that, and if you can break it down. So yeah, I think that's right in terms of kind of kicking the tyres a touch. It's reading it and understanding if it meets, and particularly we've got guidance on this now, as we said, under consent. We can look at that and see, has it been unbundled? Is it granular enough? Is it clear enough? And does it pass that test? And I like the point that you raised, Michelle, also about the privacy policy. The important thing to think is it's also about making sure that we're clear about the nature of all of the processing that takes place there. And the privacy policy generally is the place that we communicate all of that. And at the point that an individual signs up, it's important that they can review the privacy policy, or in fact at any other time, of course. So that's kind of the way. But to just pick up on the second point, which was around the proof of consent that was mentioned, I think that was one of the kind of questions that came in.
Yeah.
And that's really around, I do find that this is quite often a challenge for organisations, in that the way that their databases have been created generally quite often don't have the capability as it stands to be able to link up a consent notice against an individual in the level of detail or granularity, and with that effectively what you'd need to comply with GDPR at this point. So for many organisations, many charities particularly, there'll be a need to look long and hard at the database and what capabilities it's got, and to look at maybe improving some of those capabilities so that you can record that the level of consent that will be required in the future. And the point like about a guard file is something that we talk about every time we talk about GDPR with clients, is start collecting that. If you're not doing it already, if you're not collecting your guard files, keeping copies of all your consents, one door review, make sure where you're asking, the ways that you're asking for consent, be it online, be it through face-to-face with talking to supporters face-to-face, or through telephone, etc. Have you got documentation that shows what you're actually asking for? How are you recording those? How are you keeping them? Or in fact, when it changes, will you still have a record of what you'd said before, between which dates, and being able to then link that back to customer record, which is not the easiest thing to do. Quite appreciate that, but it's something I would urge charities to start looking at, because it can take time to change your systems and change your processes. So
and
something to get started on.
It's not a small project, and there were a number of people who, when asked what questions do you have, almost used the same phraseology, which is, I don't even know where to start in terms of questions. And George, what Michelle has described as a large organisation, and what Simon's described, as a consultancy to a range of charities, would appear to be, well, it's not an insurmountable, these are big businesses, but what do you do about the small charity that is still doing an awfully good thing for society, that is sitting there saying, I don't even know where to start on the questions because we don't have money for this, and my challenge is half the people that we're going to send this wonderful transparent consent notice to don't even read it, or if they read it, they still don't understand it, and they just want to press the whatever button. is it just that we need to have charities moving in the right direction and that we can't be expecting perfection?
Wow. Thank you for that question. But let me start with, for the avoidance of doubt, I'm no longer with the fundraising regulator, so this is George's answer and not the regulator's answer. When we were looking at the concept of a fundraising preference service, we met with medium and small charities, and part of the response was, you must be out of your mind. What is this? How does this work? You're kidding me. And we had to deal with that. We had to try and be proportionate in what we proposed, but the general point to them was, you're going to invest the time because this isn't going away. And I think it's that recognition that this will not go away. You can sit there and go, I don't understand half of what Simon just said, or I'm not a quarter of the size of Michelle's outfit, but it ain't going away. I think you have to invest the time. There must be ways of doing it smart, whether it's through federations, confederations. Experts and analysts have got a bad rep through this Brexit experience, but there is nothing wrong with going out and working with professionals in the field who know what they're doing. And if you have to invest some money to do that, it's an investment. Don't see it as lost spend or lost revenue, because unless you invest and do this right, the future is not bright nor orange. That's something I would say. I think the other, to the question about what tips you have for consent notices, slightly related to my last point, beg, steal and borrow. You don't have to sit and invent everything yourself. It's out there. I think the other thing I would say to people is, ask yourself honestly, really stare yourself in the eye and say, why am I collecting this and what's the purpose? And if you are being disingenuous and you actually want the information for another purpose, if you're contacting supporters but actually you're harvesting fundraisers, be straight with yourself, because unless you're straight with yourself and know where you stand, you're not going to plan the right way forward. So I think that's where I would go. I would, as a regulator in direct marketing, absolutely endorse what's been said about evidence trail. We have had companies, not charities, but others, come to us in the data world and say, here's the process, and dump 6 inches, 4 kilos of paperwork on the desk, and the process was elegant. The practice was awful. So the question, don't just have process, have practice.
Yes.
Would be what I would say. It doesn't have to be nuclear physics, but it has to be tested working.
Yes, and I'm glad that you, and I was hoping that you'd respond in that way. Thank you, George. We've seen a number of fines and consent orders, undertakings with the ICO, where it wasn't that the company didn't have a policy, it was just there was no evidence anybody knew about the policy. And I think there's all sorts of other things we can talk about making the policy actually something that is realistic and practical. There is a specific question that we've got up there at bullet point 2. How can you lawfully use data matching and teleappending? Wonderful, wonderful phrases, and yes, we're all looking at Rosemary and Simon here. Tell us, what is teleappending, please?
Yes.
This is the lawyer asking the question.
What is teleappending? Okay, teleappending, I guess, is matching against a national database generally that holds all of what in theory are the most up-to-date telephone number for an individual. So therefore you could use it for verification purposes. So if you've got an existing telephone number for that individual based at a certain address, to say, do we think this is still a correct number against that individual? And let's just take that one. I can't really see any problems with that personally, to verify a telephone number against a list, because that's got to be good practice, as in under the current Data Protection Act, and it'll be just the same under GDPR. We have a requirement for accuracy under that, and to keep up to date, so don't see a problem with that. I think part of the challenge where it can get into hot water around teleappending is where you've got a blank. You don't have a telephone number, you're appending it to be able to add another telephone number on without the knowledge, and I think that's particularly been the challenge in the past. The more recent ones around, I think it was RSPCA and British Heart Foundation, around those, is where what the regulator called invisible processing. So nobody knew you were doing it, respectively. So part of this, I guess, comes from having a clear notification again, your privacy policy. Make sure that you're telling people in good, clear, plain language what you'll be doing. But there's another challenge, of course, around teleappending, that if you add somebody's telephone number without their knowledge, even if they knew you might teleappend, you've still got a challenge that they might, of course, not want telephone calls from you. Depending on how you've collected your consent, they might not want it. Or even if they did give you a consent at some point but didn't give you a telephone number, this was part of the also argument, they might not want to hear from you, or they might have deliberately given you a false number.
Or they might have put themselves on the telephone.
Or they might, of course, have put you on the telephone preference service as well. So it is a bit of a challenge. So I think around verifying existing numbers, I don't think there's a problem with that personally, but around adding additional numbers certainly is challenging around that area.
Okay, and again, sort of picking up on something George was saying, which was, you should really look in the mirror and start asking yourselves, do we actually need to have that data, collect that data? Yeah, there's a question we'll come to a little bit later on about data incidents or breaches, and it's when it all goes wrong that you're going to find it difficult to answer the question, why do you have all of that stuff when some of it is completely out of date and of no value? So where is your data management? And so I do think that you need to think, do I really need this? And why am I collecting that phone number? And will it suddenly find that down the line it's being used for the purposes for which we didn't originally intend it? So an awful lot of this is about internal control as much as it is about what Michelle was saying, which is the external plain notice communication. Mm-hmm. So now we could spend the next half hour on the next one, which is what should we do to prepare for the General Data Protection Regulation, e-privacy regulations, and also the fundraising guidance. Simon?
That's a very big question, Robert, isn't it? What should we do for GDPR, e-privacy, and fundraising guidance? I think the starting point, kind of from any of these sort of things, is just to understand what it is that you're doing now and why you're doing it. Get back to basics, really, I guess, would be my view on this. So start to review what your purposes, first of all, are for processing. What kind of processing is it that you want to do? How are you going about that? Are those purposes, I think as we said here, are they genuine purposes? What are you really doing it for? What's the ultimate motivation? Are you being clear enough about how that's happening? So effectively, conduct a review, and that sometimes you'll need some help to do that. Sometimes it's the kind of thing that you can do yourselves. To be able to identify that, and then start to break it down into what kind of legal basis have I got for that. So if it's marketing, direct marketing, will that be with consent? Are we going to be looking to use consent for that? Looking also, which kinds of processing you can do under another legal basis. So what am I doing? So things like gift aid, for example, you wouldn't need to rely on consent for that. So that kind of thing. Pertinent for charities, and then to understand where are your risk areas. So if there are certain things that we're already doing or we're proposing to do that don't fit, because obviously you're going to have to spend a bit of time reading up on these to understand GDPR. Obviously we're only at the very early stages of e-privacy yet. We've still got a draft text, but obviously we've got very much the fundraising guidance is already out there to understand from the point of view of now that we've really got to grips with the processing that we're actually doing in practice and understanding the systems and what actually happens practically, how the process is really working. You can then judge if there are any risks in those areas, start to prioritise and understand where your risk areas are and start to tackle them in an orderly way.
Yep, good points.
My suggestion.
Yeah.
Telly, common-sense approach on it.
Well, I'm in agreement with Simon. I think it's a risk-based approach. Business exists today, so you do need to review what you're doing and go through each touch point and then each process that leads to. And then the final piece, what is it you're going to do with the data? You've captured it, you've stored it, and you're going to use it. And to run and to swatch up on GDPR, as you suggest, Simon, and take each part of your business and decide on a risk-based approach, do you believe you're compliant? And if you're not, how and what are you going to do to change? Or, the very worst scenario, are you going to cease doing that part of the processing or capture or storing? What is it you need to do? So retain what you're doing, but informed by your privacy policy, stop what you're doing, improve what you're doing so that you are compliant. And it's very time consuming, and I think always common sense should prevail. I think there's a lot of mythology, and strip it all down and run a subject access request through. Put a complaint through your system. Does it work?
Test it.
Yeah.
I myself have a number of identities that my team don't know about, but I run through the business regularly just so I can see what the outcome of certain data requests are and so forth, which is, even I guess even if they did know about them, they know about some of them, it would be good. So I think it's very important to stress test your own processes. So.
Yeah, and I think this has got to be a cross-organisational kind of effort. This is not just only about fundraising. It's got to be across the piece, and everyone should be involved. The trustees of the charity should know what's going on because it's being done in their name. And a lot of those trustees, in terms of the approach to direct marketing, direct marketing from a lot of trustees since the Daily Mail debacle has been to hide under the table and really prevent a lot of direct marketing. Now, that's perfectly understandable, but I think it's not sustainable going forward. As we've said, fundraising is a perfectly legitimate activity, and the preparation have to involve everyone in the organisation, including and specifically, importantly, those at the top as well as those at further down. And it has to be, so it has to be cross-organisational. That spreads the effort. It has to involve all key functions. So as we pointed out, and you've said, Michelle, the system changes that have been required, and they can't be done overnight. They will take some time. They will take some planning in. But equally well, there are cultural changes, behavioural changes that you're going to have to instill in people in the organisation to make sure that GDPR is you're ready for it.
George, anything else to add?
I've been gazumped here. Like Michelle, I have various persona because I ran the Online Dating Association for a while, so I used to test services there. Many of you out there will know me from one character or another. I was absolutely going to say, buy your trustees a jug of coffee and lock them in for an afternoon. So I totally agree with Rosemary. When I was working on fundraising regulation briefly, I did have a sense of, the phrase that defined American policy for gays in the military, don't ask, don't tell. And as an element of don't ask where the money comes from, and I won't tell you where the money came from. Yeah. And I think that's not sustainable.
No.
My one suggestion, not being a practitioner, but it just seems to me, particularly for the small, medium-sized charities, is you're all at it. Think about peer group reviews. Think about other people in your sector that have been through this or may have been through it differently, and sit down with them. And I think getting away from the concept of the law, I would just think, again, as a fundraiser, what are my touch points with people? When do I engage with people? When am I going around categorizing them as this is not shareholder stock, stakeholder interest or supporter benefits, but actually, is this a marketing touch point? And that honesty that, yes, it probably is a marketing touch point, and think about what the implications of that are.
And I know we're talking about fundraising, but I agree with Rosemary that it's really across every part of the business, because when you look at the things that we've got to do with GDPR, it's about what contracts do we have with third parties who will be managing our data, whether it's hosting the website or it's a call center that we're using, and where are they in the march towards compliance, and are we going to have to renegotiate the contract with them, and what happens if the current contract goes way beyond May 2018? There is no grace period. It's you're either compliant or you're not, and I think at least starting the process is better than sitting on your hands and wailing, because if something goes wrong tomorrow, you can at least say to the regulator, we are moving in a direction, as opposed to we've just buried our heads in the sand. Okay. A specific question, is a membership magazine a membership benefit, or is it direct marketing? And I quite like that question. I sat there for a minute and thought, well, you know, I'm a member of various things and I would expect to get a members magazine. I don't see the receipt of it as direct marketing, but then inevitably other things that are within the magazine or around the magazine go beyond a membership benefit. So is it that there's actually a line that you just have to manage, or is it as simple as it's a benefit, period? George?
I was going to have a go. This came up when we were thinking about having a fundraising preference service, which communications were included. Was there any such thing as a non-fundraising communication if the whole relationship with your donor community was, the end purpose was to solicit support for the purposes of the cause? We, as I recall, came down with the conclusion, I'm an outcomes-based kind of guy, that you could test and the regulator would have to exercise judgment about what was the primary purpose of the journal. And I think if I get the National Trust magazine or whatever it is, I think it's a fundamental, integral part of being a member of that organization. I think you could see others, you know, sending out a newsletter which is 75% solicitation of funds. I think some of the things from higher education establishments are a very interesting test in terms of what you get as alumni and how often you're being targeted for something other than an old boys reunion. So I think primary purpose, I know that puts a burden on regulators, and I know, you know, some regulators don't like having to make those judgment calls, but I think life's about judgment calls. And the alternative is to prescribe everything, and that's just not a world, I think, that's sustainable. And that's not sustainable when we talk about magazines. These magazines are now digital.
Yeah.
You know, it's not about what comes through the letterbox even.
And the point is, if they are digital, then you know, potentially, if they are marketing, then clearly you've got PECA to deal with, the Privacy and Electronic Communications regulations to deal with as well, and the consent requirements under that. So I think that it is more challenging for the digital magazine to describe itself as, or to be assumed as a pure benefit and non-promotional.
Okay, so we've got about 20 minutes max left, so I'm going to move on to the next one we've got here, which is we've had consent guidance or consultation. Will we get legitimate interest guidance? So, Rosemary, do you want to talk about where we're at on what we're doing and where you think that is heading? Yeah. And I'll tell you whether I agree with you or not, as the chairman.
As the chair of the working party, I hope you will agree with me, Robert, but it'd be a first. So we are, as the Data Protection Network, we have created a working party, and this working party has a number of trade associations. We have the DMA, we're delighted to have the DMA involved. We have the ISBAR involved, the Institute of Incorporated Society of British Advertisers, and we have a number of very prominent brands, a significant number of very prominent brands sitting around a table, and we've brought them together specifically to discuss and produce guidance on the use of legitimate interests for processing under GDPR. There had not been any indication of guidance coming from regulators on this, so we therefore took it upon ourselves to start the discussion with regulators as well, and we have created some guidance which is still in draft form, but we are hoping to share it with the regulator in the course of the next few weeks. We were delighted actually when we asked the ICO, we told them what we were doing and we said, would you like to see it? What, you know, are you happy to sort of collaborate with us on this? And they were very welcoming, and it is actually something that the GDPR does call for. It calls for groups, trade associations and other groups, to come together and offer guidance for approvals. That's exactly what we're doing. We think legitimate interest is going to become a very important area going forward for a lot of organisations, because the barrier for consent is absolutely incredibly high, and it is a significant opportunity, I think, to clarify when legitimate interest can be used without regarding it as a get out of jail free card. What we would, for the work that we're doing, one thing that we would absolutely welcome is where organisations have in the past or have considered legitimate interest as an option, and the specific processing that they are that they believe they can rely on this particular ground. We'd like as many examples as possible. We want our guidance to be full of real practical examples of when legitimate interest may be applied.
Yeah, and I think some of what we're doing is trying to actually define subsets of legitimate interest, because if a privacy notice under GDPR has got to specifically say what is the ground that you are relying upon, to try and make a plain language, succinct statement about a category of legitimate interest is really rather difficult. So much like a few years ago with the cookie guidance from the ICC, you had strictly necessary and performance and functionality. They subsequently gained a quasi-legal strength, and I think that's what we're hoping that we might get here with things like strictly legitimate and core legitimate and essential legitimate, and to build that up, as Rosemary says, we need more examples of where consent can't work. And it's quite clear from the ICO's current consultation, she recognises that consent is not the solution, and there are some extremely good processing activities which have a humanitarian or societal outcome, where so long as you've done the balancing test and you can show that the right of the individual is not abused. And this is all about accountability and transparency, and so I think this is an important area. But George, you're signifying you want to make a comment.
I haven't got a comment, I've got a question, and I absolutely don't know the answer. But I picked up in a meeting that one of the issues with legitimate interest, and the ICO was, if I can describe it this way, you pick your defence and you stick with it. You either say, I have consent, or I have a legitimate interest in doing something. You can't say I've got a legitimate interest, and when that fails, turn back and go, oh, well, actually, it doesn't matter because I've got a consent, or the other way around. Is that right?
That's a legal point.
Well, again, actually, we've got a question in that is sort of around this, which is which trumps which? And, you know, if I have spent time saying I'm relying on legitimate interest because I've done a balancing test and I've done a legitimate interest assessment, and I believe as a charity that I can substantiate it, what do I do if one individual says, I believe you cannot in my case? Well, you might have to accept that actually they have a case, in which case, well, then what do you do? Because if they're saying you can't have it, equally that means you don't have my consent either. Does that mean you then, and this is what this question says, is do I then have to change my entire approach for the entire database? That I don't have an answer to, but actually this is part of why this work that we're doing, I think, is valuable, and why the ICO herself says actually we do need to get feedback from industry, because unless you tell us the challenges you have in the real world, you know, we sometimes sit in our ivory tower and we absolutely don't know.
I think being clear, you know, making that decision as to whether it is consent or legitimate interest is an important one. It's not one that organisations have kind of had to make in the past.
No, true.
That's the problem. You know, it's oh well, it's one or the other. We don't really.
Yeah, and somebody has also made a comment here as well, or quasi-question, which is very specific. Looking at page 16 of the consultation paper, there is specifically reference to legitimate interest, but only in relation to private sector organisations. What's a charity?
Yeah.
You know, what's a not-for-profit? Well, I think it is a private sector myself.
Yeah.
It's certainly not public within the sense of public authorities and so on. So I still think there is a lot that can be done with legitimate interest, not a get out clause, but if you can substantiate it, of course, it also means that the right of portability does not apply because you're not processing on consent. And so, for businesses that are worrying about how do we manage this portability thing, and here is yet another expense we're going to have to do with systems and we have no money, there's a lot to be said for this, but it's early days. But I would say, when you're doing the analysis that George mentioned earlier, when in fact everybody said about what have we got and why have we got it, don't forget consent is only one mechanism that, manages your lawful processing.
I think one scenario, Robert, that charities might find themselves in is a mix of both. So retrospectively, or their current databases that they, I suppose in monetary terms, have invested enormous sums of money acquiring donors, communicating with them, generating income. Those may well have been collected lawfully under legitimate interest, implied consent, with appropriate signposting to opt out, and acknowledge each charity perhaps has, or we've decided that we will consent going forward. So there you are, we have a database that will hold a retrospective and a future moving group. I suppose time is a great cure because as time goes on, the recency factor means that someone who is currently 1 year old in 2 years' time probably won't be contacted because their recency will then be 3 years and their response rates arguably will be non-profitable. So is it a measure of the sands of time rolling as you move from one to the other? And how do you make that demarcation between the two?
I just, back to my fundraising days briefly, as George, on legitimate interest, I think my health warning would be to this sector, do not just grab this and believe this is pass go and collect £200. A lot of the grief with the Daily Mail, inflated or not, around the sector was the perception that it could do anything it thought it could do because it was doing it for a greater good, and it's fundraising and it's for a good cause, therefore this doesn't apply to me. To grasp at legitimate interest and say a good cause means I have legitimate interest is a hazardous approach.
I agree with you absolutely, and this word assessment, we must remember that we've got to bring that into all sorts of things that we do, and it's got to be instilled across the business that, rather like a privacy impact assessment or privacy by design, before we go off and do this great new wonderful thing that's going to raise this, that and the other, stop. Should we be doing this? Just because the technology allows us to doesn't necessarily mean ethically that we should or legally that we should. And if we do go ahead and do it, we better have some mechanism where we can show the regulator the methodology that got us to where we are. So I've got 2 more questions that I want to finish with. I'm going to go to the last. Sorry, Simon, yes,
Before we do
please.
that, I'd just like to add one little point, a little myth bust, if I might. One question I've heard a couple of times before, and I thought just in case there's others, on the webinar that mentioned this, you can't kind of switch from consent into legitimate interest to basically to contact individuals that have opted out. You have to say, actually, I haven't got consent, I'm now going to use legitimate interest. That's not going to work, just to be clear on that one. I've had that question a few times. And within that assessment, just to make sure that everyone is clear that assessment has to not only balance the interests of the charities, but balance them against something, which is the rights and freedoms of those individuals, one of which, of course, is a right to opt out. So clearly, from that point of view, just to make sure that we're everyone listening is aware of that part, to be able to make a proper formal assessment, and that's what I think the guidance will help to achieve, is to set out how that balancing act can be done. And sometimes that'll be a relatively simple assessment in some cases, sometimes a more complex kind of planned formal assessment.
Okay.
Sorry.
So as we sit here pondering about how do we substantiate our business and some new app that we're going to launch or some new way of contacting donors, we've got a question right at the bottom. How do we decide if we must have a data protection officer? And I raised that one now because the final question, should we have time, I want to do is what do we tell the ICO when it's all gone wrong? Do we think, George, that this sector will be caught by the mandatory requirement to have a DPO?
I don't know, because I've walked away from it a few months ago, and I would rather bow to somebody's superior knowledge.
Okay, well, Michelle, you're more superior. Come on,
in every way.
Oh, I don't know about
There we
that.
go.
The answer is I don't know, but I would imagine it would depend on the size and complexity of the organisation, the number of touch points, the volume of data that you are acquiring, storing and using. So,
And the sensitivity.
absolutely.
Think about that,
Yeah,
because a lot of charities are dealing with sensitive data
They
too.
are.
Yeah, I mean, I sort of my take on it has been that for many charities, in fact for many businesses, this is not mandatory, but there might be situations where you are dealing with children's data or with specific health related data, and your international and the volumes of it are such that you must have one.
Yes.
I think a really interesting question is well, if we don't have to have one, what do we do?
Who does it all?
And who does it? And should they be called DPO, or should we give them another title? Because when you look at things like privacy impact assessments and privacy by design, GDPR keeps saying that the DPO must be front and center in the decision-making process, and in certain circumstances it's the DPO that has to go to the regulator and say, you know, I need you to be aware we are doing this new processing activity, but here's all the checks and balances we've got in place. And as the lawyer, I would say if you don't have to have a DPO, you still need somebody with the relevant expertise, either internal or external, and, you know, on a helpline, on fast speed dial. But if you don't have to have a DPO, don't call yourself the DPO, because then that brings to the business certain liabilities that are mandatorily attached. So by all means be a data privacy analyst or expert, but not a DPO. Can I just turn to one? What do we do if we've had a data incident? This was a specific question from several people. So let's suppose that we are aware that we've inadvertently sent a donor list to the wrong person by email, or we have lost a big memory stick, or we have been hacked. Do we tell the ICO? Do we hope it goes away? What do we do? George?
I'll try better with an answer this time. I think you tell. It is my starting assumption, and my read across is in the ECommerce Directive, and the ECommerce Directive, which is about digital commerce, has this concept of mere conduits and knowledge, and the proposition was that an internet service provider wasn't guilty of any crime as long as they didn't know what was going on.
Yeah.
Once they knew what was going on, they were, quote, with knowledge. And I think if you are with knowledge of an event and you choose not to report it, you then have to explain afterwards, when it appears on the front page of the Daily Mail, that you knew, you had knowledge, and you did not act on it. And I think if you're in a bad place, don't make it worse.
Yes. In the current climate, of course, if you're not regulated, there isn't a requirement generally to report it now. So you could make a commercial decision that, yes, we lost some data, but it actually wasn't very much and it wasn't very sensitive, or yes, we lost the memory stick, but we found it again.
Yes.
And there are some, but
proportion.
now it becomes much harder under GDPR because of the 72 hours of discovering. And I think that is where you've got to have a plan.
Yes.
You've got to have a plan, because the ICOs, the enforcement officers have always made it clear, if you do not tell us and we learn about it through Twitter or some third party or the newspapers, you can expect it to be a lot worse than if you had come forward and said, you know, we have had an incident, but this is how we're managing it. Because again, the ICO doesn't want to be caught on the back foot. When the journalist rings up and says, are you aware about this? And so I think that in amongst all of the other preparation, there has got to be a master plan.
It's the trustee point of view.
For what do you do, you know, within the first second, the first minute, the first day, and have you got your communication people on speed dial and your forensics people on speed dial and all of those sorts of things, so you don't have the hideous issues, you know, that we've seen in the past with chief executives in front of a camera who have no idea what to be saying or say completely the wrong thing. I mean, Rosemary?
Absolutely. I think a plan that kicks in immediately any kind of significant breach has taken place, that allows for escalation, so that, yes, the trustees need to know. They need to know that they might find themselves questioned on this, but also escalation, but containment, all the good stuff that's already there under the current Act and the advice from the current advice from the ICO. But I always add into that your point about managing the communications as well, because it is important that those communications are proportionate to what has happened. I mean, there could be a high volume of donor data involved, but it could be simply a name and names and addresses. There could be no bank details, no in any way sensitive data or confidential data, and that's a very different thing from even a very small number of records that have people's, you know, health conditions attached.
And I think the thing also to plan for is if the worst happens, you can expect also that questions will be asked about your general level of compliance. And then everything else that you've been sitting on your hands about is going to come unravelled. So, you know, that we've sort of reached the end of our allotted time. So I would just finish by saying doing nothing is not an option. It may seem a big hill to climb, but actually, you know, taking some small steps does start to make it easier. And for all sorts of reasons, understanding GDPR is a very good start, and I think Simon mentioned that earlier, and actually looking in the mirror, as George said, and asking some fairly basic questions has to get you on the right track with the trustees and everybody else. I don't think it can be left to the day-to-day management. The board, so to speak, needs to be involved. So from me, Robert, thank you to George and to Michelle and to Simon, and thank you also to Rosemary. We hope everybody has enjoyed the webinar. As I say, you will be able to download a recording in the next few days, and we will be happy to answer any specific questions if you want to send those through to us after the event. And if you would like to suggest some other topics for the future, please do email those through. We'd be very happy to consider them for a future event. So from all of us here to you out there, thank you very much, and we look forward to being with you on another occasion. Thanks. Bye-bye.
Thank you.